So we will go ahead and call the first case, which is Meemic Insurance Company versus Fortson.
Good morning, Your Honor. Jim Gross appearing for Meemic Insurance Company. Seated with me at counsel table is Mark Creeder, who's our trial counsel. This is a no-fault case involving the denial of a claim pursuant to a contractual provision which allowed the carrier to void the policy for an intentional or material misrepresentation. The Court of Appeals refused to enforce that provision, and here we are. The appeal raises four basic questions. One is whether there is an innocent third-party doctrine in Michigan. One is whether a trial court has equitable discretion to decline to enforce an unambiguous contract provision. The third is whether a post-occurrence cancellation of a subsequent policy can affect rights accrued at the time of the occurrence. And the last is whether Section 3114.1 of the No-Fault Act nullifies policy conditions as to a person seeking benefits under the policy. Resolution of the first three of those questions is pretty straightforward, so I'm going to spend my fire-free time addressing the 3114.1 contract nullification argument, which is issue 2 in our brief. Ignoring the fact that Justin was a resident relative, the Court of Appeals held that if he were not a resident relative, defined as an insured under the policy, he would be entitled to recover under 3114.1. He therefore had a statutory right to benefits independent of the policy, and therefore a contractual provision that denies him those benefits is unenforceable as contrary to the statute. The linchpin of that argument is that 3114.1 creates a statutory right to benefits independent and separate from the insurance policy, which is the contractual obligation of the insurer to pay benefits under the No-Fault Act. That was the holding in Shelton versus Auto Owners, which basically said that because an insurer outside the assigned claims facility situation, an insurer can have no liability at all unless it issued a policy that somebody's claiming under. So the proposition that you're not claiming under the policy is suspect on its face. It's worthy of note here that neither the defendants nor the Michigan Association for Justice attempted to defend the Shelton policy in either of their briefs. But let's get to the merits of it. Not surprisingly, the Shelton proposition is without support in either the statute or the case law. First of all, the statutory right to benefits is not created by 3114.1 or any of the other priority provisions. It is created by Section 3105 and 3107, which confer a right to benefits and define the benefits that the insurer has to pay. 3114 does nothing more than define which insurer, if any, shall provide the benefits. It literally says, you're going to claim, if you're the named insured, a spouse or a resident relative, unless the insurer of the public transportation that you were riding, or the insurer of the employer-provided vehicle, or the insurer of the operator of the motor vehicle which hit you as a motorcyclist. It is nothing more than a priority provision. The case law cited by Shelton doesn't support using the priority provision to nullify an unambiguous policy condition. The defendant cited, or the court cited, two cases. One is Rollman versus Hawkeye Security. Rollman did not invoke the No-Fault Act to nullify anything. In fact, Rollman said exactly the opposite. This court said the policy and the statutes must be read and construed together, and that a contract is presumed to be intended to execute a policy satisfying the statutory requirements. The purpose of the policy is to pay the benefits under the No-Fault Act. More problematic is the passage from this court's decision in Harris versus Auto Club, which on its face does candidly provide some support for Shelton. The point I want to make about those passages is twofold. First, it's dicta, and second, it's inaccurate. The passage in Harris is dicta because the insurer's liability for benefits was not at issue before the court. The sole issue was whether the plaintiff could recover from a health care provider who had an exclusion in its policy if there was other insurance that covered the situation. This court was explicit that there was no appeal from the exoneration of the auto club from any liability for benefits. So all the discussion about what the auto club's liability might or might not be is dicta. Second, the quotation is inaccurate because the only basis for ACIA's exposure in Harris, as it is here and as it is almost everywhere else outside of assigned claims, is the fact that it issued a policy. It's difficult to maintain with a straight face that when the only reason I, a carrier, am being asked for benefits is that I issued a policy to the entity which the statute says defines my liability, you cannot reasonably maintain that the claim is not being made under the policy.
Mr. Gross, can we talk a little bit about the Cruz versus State Farm? So we understand in Bazzi, we held that a common law claim for fraud exists, and it's not contrary to the no-fault statute, correct? Here we're not talking about common law fraud. We have a contractual provision that excludes or voids the policy for fraud of an insured. And in Cruz, so the question, right, is contractual provisions are enforceable to the extent that they don't contradict the statute.
Correct.
And in Cruz versus State Farm, this court held that an EUO provision in the policy was unenforceable because it contradicted the No-Fault Act. So we're looking not at fraud as a common law claim, but as a contractual claim. And is there a provision? What is the argument that the fraud contractual exclusion doesn't contradict the provisions of the No-Fault Act?
Let's directly address what Cruz actually held.
Okay.
Cruz held that the provision in that case was not enforceable because it was treated as a condition precedent to benefits. You can't do that. The statute doesn't list it as a condition precedent. Therefore, the plaintiff prevailed in that case.
The statute here doesn't list fraud as a reason for denying mandatory
Cruz
benefits.
also recognized, however, it didn't say that the provision was unenforceable. It said that the provision was enforceable so long as you don't treat it as a condition precedent. And what it said was, if the provision itself does not conflict with the No-Fault Act, so long as it's not treated as a precedent condition, and if the insured refuses to take an EUO, the insurer is not obligated to pay. That's what this court held in Cruz. So it didn't hold that any contractual provision which results in non-payment is contrary to the act.
I agree. So there's the statute 313 lists certain circumstances in which mandatory PIP benefits are not payable. Fraud in procuring the policy or in the claim or in any event is not listed as one of those. So how are those not in conflict?
Well, this court hasn't addressed the issue. The Court of Appeals did. In Cohen, this court recognized the validity of that provision in the context of a non-no-fault claim, optional coverage. The Court of Appeals in Bari held that it did apply to basically a no-fault claim. This court has not addressed that issue. So the question is, did the legislature, by omitting fraud from Section 3113B, intend fraud not to disqualify someone from benefits? I can put it no more simply than that.
A contractual provision. I mean, Bazzi says your client would still, in theory, have a common law fraud claim subject to the equitable remedy of rescission, correct?
And the difference seems important as a matter, as a matter of balancing equities, right? If your client can pursue a common law fraud claim against the insureds, in this case, who committed the fraud, a judge could then, per the Bazzi majority opinion, balance the equities and determine just how innocent the claimant in this case is. So, however, if your contractual fraud provision is permitted, then there's no possibility for a judge to balance those equities. So
That's correct.
So that feels different. I mean, maybe BASI requires us to also say that your contractual provision is permitted, even though it's contradictory to the mandatory coverage provisions of the No Fault Act, but why should it? Why is that the right answer?
Well, the problem here with Justin not getting benefits does not derive directly from my argument or from the systemic rule that we're asking. Assigned claims is there just for this situation. And that was a point that Justice Markman made in, I believe it was the Titan case.
But it's too late for Justin to get benefits from the assigned claims plan, correct?
Yes. He would be entitled to them. What a plaintiff's attorney has to do as due diligence is to notify assigned claims within a year of the accident. Then when something like this occurs, the innocent party does have a source of recovery. Anytime you're claiming under a policy that is not your policy, that you are not the named insured on, you should be also notifying assigned claims to cover this precise situation. So the system already accommodates that.
In the event that, so they're required to provide notice in the event that 3 years from now, a care provider who happens to also be an insured might fraudulently submit claims for attendant care.
Correct, and that's simply because that's what the statute says. As a precondition to claiming against assigned claims, you have to notify. You don't have to sue them. You just got to notify them, here's the situation, this is not my policy, I don't know what's going to happen 3 years from now, but I want you to be on notice that I may have a potential claim because the coverage that I have now might disappear because of something the insureds do.
Is knowledge important or not at all?
Knowledge of the fact that you are making a misrepresentation?
Yeah.
Yes. You have to understand that what you're telling the carrier is not true. And there's not much of a problem here in this case, as the trial court found. These people were claiming benefits for services that they did not provide, and they knew it. And
Doesn't your position create a bit of a windfall for your client? If it was a common law fraud claim, it seems to me, you know, the submitting the request for reimbursement for attendant care under this claim, you know, that could be rejected on that basis. Your client might be entitled to restitution of benefits paid based on a fraudulent submission. But the common law wouldn't provide this kind of a remedy, would it, to your client? The invalidation of the entire policy as to another beneficiary who, as far as we know today, wasn't involved in this fraud.
this was not an issue that was briefed, not one that I specifically addressed. But in response, I would take the position that fraud in making a claim constitutes a breach of contract,
Well,
a material breach.
let's be careful with the words we're using, right? We have fraud in the, you know, the application, that we don't have that here, the insurance policy. We have fraud in the submission of the claimant. I don't think there, as far as I know, there's any fraud you're alleging in relation to the resident relative who made this claim. It's fraud in relation to the third parties who happen also to be insureds in this case, in their provision of these services, attendant care services. They're essentially providers. And so it's as though the provider that commits a fraud and submits bills for services that they did not perform, that should go back and invalidate the entire policy, and the claim with it. And I guess I'm wondering, the fraud doesn't, in my mind, doesn't relate to the claim. Am I wrong about that? The claim of the resident relative, that doesn't relate to that claim, does it?
Oh, Justin's claim?
Yeah, I mean,
Well,
he wasn't,
Justin's-
for example, he wasn't asked to sign off on their request for reimbursement for attendant care, was he?
His claims
He was in jail.
themselves. No. In fact, I think basically the only benefits that were being provided here were the attendant care claims. So if by windfall you mean we don't pay the benefits assigned claims does, it's a windfall unless we're incredibly unlucky and get the
Well,
case
you're
through assigned
saying that
claims.
everybody, is it your experience that every person who's in this situation has to file two claims?
No.
One against the assigned claims?
You
and
don't
one
have to
against
file
the
a claim
insurance?
against assigned claims. All you have to do is notify them within a year
Is
of the
that a
act.
common practice?
Yes, it is. To my knowledge, it is. And it should have always been due diligence. It is certainly done now.
In light of covenant, why would we conclude that Louis and Richard are making a claim?
They can make a claim, they can't file a suit. That's what covenant holds. Covenant doesn't talk about, well, the term.
Are they the ones getting the personal injury protection?
They're the ones being paid the money.
Well, but are they the
No.
ones getting the protection?
They are not. They are not the.
So why are they making a claim?
They're making a claim because the definition of a claimant is someone who is asserting a right to something. They are asserting a right to be paid for their services. I'm not venturing into a statutory definition here. We didn't do that.
I'm having a hard time concluding that they're that they're making the claim under this policy.
Well, I don't think covenant holds that that a provider is not entitled to make a claim. They're not entitled to enforce it in court with a lawsuit.
They're claiming
Providers make-
benefits under the policy.
Sorry?
Right? They're seeking benefits that are available under the policy.
Yes, they're seeking.
But the benefits are given to the insured, and that is Justin in this case, isn't
Well,
it?
they're paid to the provider on behalf of the insured under 3112.
Is there any sense in which they're making the claim? I think Justice Zara's questions are very, very thoughtful ones, but are there any arguments to the effect that they're making a claim because the father is a conservator of Justin's? Does that transform a claim on behalf of Justin into a claim that somehow is more directly tied to the parents?
I wouldn't make that argument because I don't think, as conservator, he's more or less the alter ego of Justin. So I wouldn't respond to this question in that way. I think it's obvious that he's making his claim not as the conservator, but as a provider. He wasn't even making a claim. The wife was making the claim, but he was cashing the check.
And why, incidentally, was it the mother who seemed to be in the position of signing the claims and filing the claims as opposed to Justin directly?
Yes.
No, why was that the case?
Why was she submitting them as opposed to Justin?
What was the authority that she had to file those claims on his behalf?
Well, I would say the same authority that a hospital has to submit a bill to a carrier and saying, look, we provided services to your insured. We're making a claim for you to pay us on his behalf. So I don't see them as being in any different situation.
So they can make this claim, but they can't sue for the claim. They have no legal right to collect the claim, but they can make the claim? And if they make the claim, then it's fraud under the policy? Make a claim that they have no right to collect in court constitutes fraud under the policy?
I wouldn't go that far, no. I don't think there's anything fraudulent about it. It's just that Covenant Health, there's no statutory right under the No Fault Act that allows a provider to sue. That is what it holds. It doesn't hold that a healthcare provider can't submit a bill and we can call it a claim or whatever you want, a request for payment.
There's a big difference between submitting a bill and actually making a claim under the policy. The fraud would void it if you made a claim under the policy, but if it's just simply submitting a bill and hoping you get paid with no legal right to collect it.
The policy provision isn't aimed at providers. The policy provision is aimed at an intentional misrepresentation as to a material fact by any insured. These folks are not being disqualified because, as a provider, they made an intentionally inaccurate claim. It's being voided because they were insureds.
Well, and the policy language itself doesn't necessarily require that the misrepresentation be, by that insured, be related to a claim of that insured,
No,
right?
it doesn't.
It's saying, or any claim made under it. So intentionally concealed or misrepresented any material fact relating to any claim means that so long as the person who is making the misrepresentation is any insured,
Correct.
again, relating to any claim under it, it does not necessarily have to be their own claim.
That's correct.
Okay.
And it does have to be an insured, which explains some of the gyrations that MHA and the defendant are going to say, well, they're not insureds, they're providers. Well, the fact of the matter is they are insureds. They were the named insured and his spouse.
So under the policy language, we could have a situation where two insureds, husband and wife, get into a terrible auto accident. Both are severely, or one is severely injured, one has minor injuries. And they both have claims. Both are insured, so there's no requirement that they file a notice separately. And then they get divorced. And one of the parties who wasn't severely injured files a fraudulent claim. Is the other party out?
Under the policy language, they would be.
Counsel, what is the relevance?
And again, I'm sorry, just to finish the answer, again, that is why you notify the assigned claims facility within a year of the accident.
But they're both insured under the policy.
I get that, and Justin was insured here, but that doesn't stop you from putting MACP on notice. It may stop you from successfully maintaining a claim. In fact, it will stop you from maintaining a successful claim because at that point, within a year of the accident, there is insurance. But you're putting them on notice if that insurance disappears.
So everybody has to do this? Is that, I mean, your perspective would be that anyone who's receiving these types of services has to go forth and do that?
Only if you're receiving services under someone else's policy.
So your argument would be that, I mean, your perspective would be that everyone needs to go and file that.
But in Justice Clement's example, they weren't receiving benefits under somebody else's policy. They were receiving benefits under their own, correct?
Correct.
Okay, so in that circumstance, if your recommendation is that they need to notify assigned claims, then it would be broader than just if you're seeking benefits or receiving benefits under somebody else's policy, right? Because it
Yes.
would be broader. It would be not only do you make your claim under your own policy, but now you need to notify assigned claims every time you have a claim under any policy.
And now that you mention it, yes.
Okay.
I was focused here on the usual situation where you have, I mean, the red flag is always going to be claiming under someone else's policy, but you're absolutely correct. That would be the prudent thing to do.
Anytime.
Yeah.
So, okay, so everyone needs to go and just do this all the time?
Send a letter, yes. Due
Okay.
diligence, not difficult to do.
Counsel, what is the relevance that when you entered into this policy with the Fortsons, the prevailing law in Michigan, I think was Kurilovitz, which permitted an innocent third-party defense, and you said nothing in the policy that would vitiate that possibility of an innocent third-party defense. By not contracting around the prevailing Court of Appeals position at the time, wasn't the meeting of the minds that we can adduce it in this case one that suggested there was an innocent third-party defense that was available?
I can see nothing in the policy language that would tell
I
us that.
can't see anything in policy language that either allowed it or attempted to preclude it. But I'm saying the law of the land at that moment in time permitted an innocent third-party defense.
Well, I'm not sure I would accept the premise. We discussed this in our brief, and I was going to get to it a little later here. Since 1959, we have not had an innocent third-party rule in this state. There is no law. Once this court has made a pronouncement, that's the law of the land, not a rogue decision in 1976 by the Court of Appeals that simply declined to follow Keyes because, well, it hasn't been cited, and I'm going to point to a couple of statutes, and they made up a public policy argument. That did not overrule Keyes versus Pace. There has, at least since 1959, there has never been an innocent third-party doctrine in this state. And again, the reason for that, for the situation, is like the Court of Appeals did in the Covenant cases. Instead of re-examining, every time somebody made the argument, the Court of Appeals just kept citing the case that agreed, said, we've already addressed this, we're not going to bother. It's an unfortunate situation that the Court of Appeals went off on that and maintained it. But the fact of the matter is that your premise is questionable because the law of the land was not that there was an innocent third-party doctrine.
Justice Kavanaugh threw you a lifeline with the word "any" on my questioning. Notwithstanding that word, would you agree with me that in order for this policy to be voided, I would have to conclude, or we would have to conclude, that Richard and Louise made a claim under the policy.
As the policy understands the word, as the policy uses the word claim, yes.
Does the policy define the word claim?
No, which is why we go to the common understanding, which I mentioned earlier, which is somebody asserting a right to something.
So the policy does tell us when you have to give notice of that claim. And it says notice for a person claiming personal injury protection insurance, and then uninsured motorist and car damage and all these other things that clearly don't apply. Is it your position that Richard is claiming personal injury protection insurance?
He's making a claim under the personal protection insurance provisions of the policy, as the policy understands claim, not as a statutory definition might obtain. If you're asking us for money for services that you render, and you're an insured, and you intentionally misrepresent, we're going to void the policy, or we can void the policy. Was that responsive at all?
Sure.
Sure. Thank you, counsel.
Oops.
Yeah, you're out of time. And you used up, I'm sorry, but he used up half of your time.
Thank you, Your Honors.
May it please the court, Mr. Gross, Mr. Creeder, I'm here with my associate, Joe Harrison, and we represent Fortson's on this case. And I would propose to the court that the issue before it is whether or not a healthcare provider who commits fraud in providing benefits to one that's entitled to personal injury protection benefits under the No-Fault Act, may that result in a termination of an innocent, non-contracting insured's entitlement to benefits. Justin here is innocent of any fraud. There's never been any claim that Justin committed any fraud. Doctors would tell you he wouldn't have the capability of understanding what that is. And Justin never received a dime from Meemic Insurance Company. Justin is the only injured person, and in that sense, the only insured under the policy. The policy went into effect and applied, as the statute says, to Justin's injuries on the date of the accident being September 18, 2009. In 2013, Meemic discovered that as of 2012, Louise Fortson had submitted claims for attendant care services, and they paid Richard Fortson. Never paid Louise, always paid Richard, and Richard never submitted a claim. The money was deposited in Richard's account. Never saw a check. Richard and Louise were providers of services. They were not insureds at the time of the fraud. Yes, the policy defines insured, and they were included as the named insureds on that policy, but that policy did not entitle them to claims. As you've all indicated, I'm pleasantly surprised at the questions that you've asked because I know you know the facts of this case. In this case, Richard was purely a provider, and he was working 8 hours a day. He was sleeping 8 hours a day, but he's the only one that ever received any money, and Meemic set it up that way. Meemic approached Mr. and Mrs. Fortson while Justin was in the hospital, at Butterworth Hospital, and said, he can go to Hope Network, a head injury institute, or he can go to your home. Mr. and Mrs. Fortson opted to accept their offer to take care of their son in their home. Yes, this would be a windfall to the insurance company if they're able to duplicate what the statute says in the policy and then void the policy based on a clause that says if somebody commits a fraud, we can cancel the policy. And I think Justice Markman, in your dissent in the Farm Bureau versus ACE case, specifically addressed the idea that it would be appropriate if an insurance company seeks rescission to follow the outline that was set forth in Bozzi, and the trial court should hold an equitable hearing to see, to balance the equities and see which party is more innocent. And then the trial court will determine whether or not rescission, an equitable remedy, by the way, is appropriate under the circumstances. So we know Justin never committed any fraud. It's undisputed that Louise and Richard did. Richard and Louise are not claimants. Covenant and the No Fault Act make it clear that they do not have a claim. They were not injured. They're not claimants. And in that sense, I propose that they are contracting insureds, but not insureds to the extent that they're entitled to benefits under the No Fault Act. Justin is a non-contracting insured. He's entitled to the terms and conditions of the policy. He committed no fraud. After we talk about whether Justin is entitled to coverage under the policy, we get to whether he's entitled to it under the No Fault Act. The priority statute 3114 says Justin must look to these insurance companies for personal injury protection benefits. It's not an option. That's where he had to go. To me, having to submit a claim to the assigned claims facility may be a claim that I wouldn't want my client making because I know he's not entitled to it. This policy was in effect for at least several years before any fraud was committed.
Counsel?
Yes, sir.
In your very first sentence of your present remarks, you characterized the Fortsons as the healthcare providers, and you later described them as purely the healthcare providers. If this court finds that they're fairly characterized and identified not merely as the healthcare providers, but potentially as the named insured parties, or even in Richard's case as the conservator, do you lose?
I don't think so, Your Honor. I think that you're right that they are potential insureds, but they are not insureds to the extent that the statute entitles them to any benefits. And following the rationale in Covenant and 3112, they're not entitled to benefits. In that sense, I don't believe that they're insureds for that purpose.
Justin is the insured person.
Yes.
You said the fraud was committed by Louise and Richard, even though Louise only made the claims. Well, then what about the notion that Richard is the conservator on behalf of Justin, so that when he makes the claim or commits the fraud, he's committing the fraud on behalf of Justin as well?
Yeah, I did say that. And if I could just back
Are you
up.
surprised that I was listening?
No.
But you were surprised that we were
I'm
prepared.
surprised because you know as much about this case as I do, and you've not
shouldn't be
had it
surprised.
since 2009 like me.
You really shouldn't be surprised that we're prepared.
I'm not surprised. That's not what I meant. What I meant was there's a lot here. I've been living with it since 2009, and I'm impressed, maybe I should say. Thank you. But,
Okay, well, okay, well, with that, can you answer the question?
yeah, Richard never submitted a claim. He didn't fill out a form. Louise did. Richard was appointed conservator, and it was Meemic that decided that the payment should go into Richard's account because he was appointed the conservator. He, and that's how that ended up. I forget exactly, Your Honor, what the question was, at the end of the question.
If Richard is a party to the fraud as conservator, does that not make Justin the insured?
No, I don't think so. I
And a
agree.
claimant, and making a claim?
Well, he's not a claimant entitled to benefits. He is a provider, and the statute does allow the insurance company to pay a provider directly under the statute. It doesn't have to, and it has no obligation to pay Richard. They may pay Richard under the statute, but they don't have to under the
The problem with your clients is not that they're a provider, it's that they're also an insured, in fact, a named insured, the insured. I mean, there's nobody who's more insured than your clients, right?
Richard and Louise, yeah.
Oh, correct, Richard and Louise. So, because if these services were fraudulently provided by someone by his best friend or a, provider that you hired, we're not here, right? We're not talking about this contractual fraud provision because they're not insured. So, and the statute doesn't speak in terms of providing benefits to an insured, right?
Right.
So whether, those are you conflating sort of how the policy defines who's an insured and what the statute requires? When you're talking about who's an insured, it's strictly a matter of policy.
I agree with you, but I would point out that the policy starts out on the first page. It says, "We enter into this agreement with those persons named in the declarations page," and that's Richard and Louise. And then the policy later defines insured. So at a minimum, I would propose that there is at least an ambiguity on that issue in the policy.
Okay, what about, but I think maybe perhaps your client's strongest argument is that a contractual provision in the policy is enforceable so long as it doesn't conflict with the no-fault statute. If it does, then to that extent, it's not enforceable. Where, and in what instance do you believe that the contractual fraud provision would conflict with the no-fault statute, such that you can enforce a contractual fraud exclusion, even though BASI may give you the right to give Meemic the right to bring a common law fraud claim?
Yes, I think under Section 3114, Justin is obligated to seek benefits from his parent's policy as a resident relative. The fact that the policy mimics and parallels that part of the statute, it doesn't change the fact that the insurance policy cannot eliminate the coverage that the No-Fault Act affords. So I would say that 3114 is the provision that would be violated if that portion of the policy was enforceable.
And what about 3113, where it specifies under what circumstances a person is not eligible for PIP benefits, A through D, none of which include the fact that if you have committed fraud or somebody has submitted a fraudulent claim?
Yes, so I would suggest that at least the legislature considered under what conditions an insurance company may be able to void a policy or avoid coverage under the statute. And those 5 provisions in there don't include the provisions that Meemic is attempting to use to avoid coverage in this case.
Okay. That in addition to 3114, you think
Yes.
as well? Okay.
Yes. Thank you.
Is there any provision of the No-Fault Act, Counsel, that prohibits Meemic from mimicking, from defining an insured person as that term is otherwise defined
No.
in the Act itself?
I don't know of any, Your Honor, but I think the absence of it doesn't mean that that opens up that possibility as an avenue to escape coverage.
And I was trying to listen carefully too, just as Justice Zara did. And perhaps I don't do as well as my colleagues in that regard, but you did mention the word rescission. What exactly is, how is that term appropriately being used to describe what Meemic was doing here? I thought they were simply trying to invoke the fraud provision in the policy. That wouldn't involve rescission.
Well,
Rescission is an equitable remedy, isn't it?
I believe it is, and I believe that what the policy says is they're trying to void the policy. And I guess the question that comes to my mind if they're able to do that is, does that mean that all of the 3 or 4 years of payments that Meemic has made has to come back to Meemic? Do they now go back to the providers, all the other providers, and say, hey, that policy was voided, we get our money back? I mean, it's kind of a ridiculous outcome if that were a possible.
Well, it may be, but they're trying to do what they can with the policy because they think that the policy provides for them doing that thing, don't they?
Yes. I guess I think the cases that I've seen, the terms void and rescind or rescission are used interchangeably. So I suppose that's where the term rescission has come into the agreement.
Is there a difference between, I mean, when you're talking rescission or fraud in the application, it's void ab initio, right? As
Yes.
if the contract never existed, which perhaps may allow any benefits paid under that. There may be a difference in voiding it as of the date, voiding it upon the occurrence of a fraudulent misrepresentation, which void is not necessarily the same thing as void ab initio. I mean, they're temporal,
I
right?
looked and I could find nothing to help clarify that for me.
Okay.
Not to be throwing any cold water or anything, I agree with Justice Kavanaugh that that argument concerning the concealment or fraud provision and its conflict with the No-Fault Act is a pretty significant issue here. But did you actually raise this issue in this court?
I'm sorry, I didn't follow.
Did you raise the conflict issue in this court?
The conflict between the voiding
Between the
policy-
concealment or fraud provision and the No-Fault Act?
Yes, Your Honor, I believe that the position of Meemic, or the position of Fortson has always been that even if the policy could be voided, he's still entitled to benefits under 3114, and to the extent that that policy conflicts with his entitlement to benefits under 3114, then it would not be enforceable.
So you believe you've actually defended what the Court of Appeals said in that regard?
I believe so, Your Honor.
I see no additional questions. Are you
Yeah, I'm
satisfied?
I'm satisfied, yes, Your Honor.
Thank you.
Thank you.
The case will be submitted.